Okay, hi. Welcome to this morning's session of the Kansas Court of Appeals. I'm Karen Arnoldberger. I'm the Chief Judge of the Kansas Court of Appeals, and I notice in this video my head keeps disappearing here. I hope you'll bear with me. We are here today to call the Monday, May 10th docket of the Court of Appeals. With me today are Judge Stephen Hill, who is the longest serving law-trained judge in the state of Kansas. And on the other side is Judge Patrick McInerney, who was a full-time judge on our court for many, many years, former Johnson County District Court judge, and is now serving as in a capacity as senior judge. So with that, I will call the first case for this morning. Remember, as you all are familiar with oral arguments, but we've read the briefs, we've read the facts, we know the facts of your case. You only have 15 minutes each to argue, so you really don't have to spend a lot of time on the facts, except to the extent that they are relevant to the legal arguments you're making. So with that, if I could, I'll call the case 122-209, Robert K. Ferguson versus State of Kansas. If the parties would state their appearances, please.
May it please the court, Stephen Alexander appearing on behalf of the plaintiff appellant, Robert K. Ferguson.
All right, thank you.
Your Honor, may it please the court, Ian Audie appearing on behalf of the appellee, the state.
Okay, thank you very much. Mr. Alexander, did you wish to reserve any time for rebuttal?
Your Honor, I would appreciate reserving 2 minutes.
Okay, thank you. We will certainly accommodate that. And with that, you are free to go ahead and begin.
Very well, thank you. Good morning, everyone. We have a case that we need to argue this morning with regard to the dismissal of a 1507 matter. I want to talk about 2 due process violations. The first one has to do with my client filing his motion to reconsider the dismissal of his 1507. The second having to do with the 4th claim of ineffective assistance of trial counsel as set forth in the brief, the failure to object to any DNA test performed in which my client's blood was used for comparison. Now, focusing on this 4th claim does not mean that we're abandoning or waiving the other 3 ineffective assistance of counsel claims. The time is short, and we feel that the address of the other 3 claims is adequately set forth in the brief in the case. Now, to begin with, the district court held that my client's motion to reconsider was not timely filed under KSA 60-259 and 206 within 28 days of judgment entry. My client responds that the dismissal of his remaining 1507 claims was a due process violation, and in addition, KSA 60-260 gave him the right to file the motion as well. The case facts indicate that the original motion for 1507 relief
for just a second, Mr. Alexander. KSA 60-260 would allow the court to grant relief for any reason that justifies relief. And that requires filing within a reasonable time. This was some
correct
10 years after, maybe slightly less than that, but a matter of years after the decision was made, dismissing the 1507 that you filed this action. So I understand your due process argument, but there has to be a vehicle to bring that due process argument toward the court. And you are resting, it's my understanding, you are resting this case on your ability under 60-260 to bring this. Is that correct?
Under the circumstances of the case, yes, we're contending that obviously
60-260, this is, you do not want this considered as a new 1507. This is you rise or fall under 60-260. So the question then becomes, how do we determine what's your best argument that this 10 years or 8 years is a reasonable amount of time? Or is not
argument,
unreasonable.
Your Honor. Oh, I'm sorry. Yeah. The argument is that, as reflected.
Okay, you've frozen, Mr. Alexander. I don't know if you can. Abby, do you have an email or something you can send him and let him know he's frozen?
Sure.
Fortunately, anybody listening, this happens from time to time. We are hearing cases from all over the state, so sometimes technical difficulties occur. Okay, maybe he's going to get off and get back on again.
Do you want me to pause anything?
Well, I don't know what you usually do in this situation. Were you able to reach him?
Well, I sent him an email, but he hasn't responded.
Well, he's gone off, unless he is Heather Jensen, if he's on it, or.
No, that's the captioner.
Oh, okay. Okay. Do you usually pause the, oh, wait, here we go.
Okay.
Oh,
Hello, Mr. Alexander. Sorry for that.
I'm so sorry.
That's all
I
right.
don't know.
I've been watching, and I'm not holding that against you for your time. So
Yeah,
if you want to go ahead, the question was, how is the delay in this case a reasonable delay?
Your Honor, my client filed an affidavit at the time that he filed his motion to reconsider, and also he testified at the evidentiary hearing that we had in this matter. So the question, I believe what you're asking is the issue is whether my client's motion should be barred due to the time lapse between the original February 28, 2007 hearing, where his remaining claims were dismissed, and the January 20th, 2017 filing of the motion to reconsider prior decision and final order.
Right, exactly.
So the point here is that obviously the state is arguing, and the district court took the position that my client's motion was not filed within a reasonable period of time. As I've just explained, my client submitted his affidavit at the time that he submitted his motion, explaining the time lapse. And he also, as indicated in his testimony at the hearing, explained the time lapse. If you take a look at the motion, at the affidavit and the testimony, he was never advised that his remaining claims were dismissed. He thought the claims had been dismissed on the merits. Once he found out otherwise, he then filed his motion to reconsider. Reviewing the affidavit that my client had filed, incorporated within his testimony at trial, my client hired counsel to represent him in the 1507 in March of 2004. Having received no response from counsel, his sister contacted the law firm that represented him in the summer of 2007 and spoke with the son of the attorney who had represented him, who had apparently passed away in June of 2007. He was advised by the attorney son that no member of the firm had appeared before the district court at the February 2007 hearing to argue the merits of the remaining motion claims. The attorney's son did advise that he would further review the matter and contact my client's sister. Having not heard from the law firm, my client's sister wrote the law firm in January of 2008 to further inquire about the case. The attorney's son responded in a letter dated January the 28th, 2008, reviewing the situation and simply concluding, I hate to be the bearer of bad news, but it would appear from all of the facts which I have before me at this time that we hit a proverbial dead end. Therefore, thereafter, my client signed a consent form that was sent to him by the law firm for the case records to be sent to his sister. His sister subsequently received the records from the law firm in 2009, and those records remained in her possession until late 2015 and 2016 when my client began his own review of the reason for the dismissal.
Is there any reason that he didn't get those in 2009 when she sent them, when Holland's firm sent them to her?
My client indicates that because he was in custody for safekeeping, the sister kept those records in 2009 through early 15 and 16,
Okay.
Your Honor.
And it's my understanding that back in 2007, when the case was dismissed, he received something that he signed off on indicating that he realized the case was dismissed. Now, he says he didn't read it. And I suppose the other argument is that it didn't tell him the case was not dismissed on the merits. So he still believed the case was dismissed on the merits. So then we go to trying to figure out where the record is. And now his sister gets it in 2009, and then he doesn't look at it until 2015. So you believe that's reasonable to go from 2009 to 2015 and never look at the file?
Well, the explanation for that is that apparently a colleague or someone that he was acquainted with in the institution had done some research, as prisoners often do, about the status of other prisoners' claims, and determined that there was never a resolution of this case on the merits. And that's when my client then decided to look into this further and then subsequently file his motion for relief.
Okay. Thank you.
And that's the explanation, Judge. Yeah.
Right.
He believed back in 07, excuse me, that the case had been dismissed on the merits. And he's now wanting to argue the merits of a number of those same issues because he believes they have merit. And that's why he's reasserting all these. Wouldn't the reasonable course of action for someone who believed their case had been dismissed on the merits in 2007 would be to visit with a lawyer about pursuing the matter on appeal in 2007, as opposed to now?
I'm not quite sure, Your Honor, that I understand the specific nature of your question.
Well, you're saying what's the reasonable course of conduct that should be applied? And I'm asking if he believed that his claims had merit and were entitled to a hearing, which is what he's pursuing right now. Why did he not contact his lawyer in 2007 and have him at that point file a notice of appeal?
Well, it would appear that the lawyer that was representing him in 2007 had been ill and had passed away in June of 07.
Well, but this was in the court dismissed his claims in February of 07.
Correct. Yeah, and the affidavit and the testimony is what it is. Having not heard after a period of time, then his sister contacted the law firm in January of 08 to inquire about the case. My client was not aware that his claims, I don't believe from the affidavit and the evidence, he was not aware that his case had been dismissed in 07. He had never received a communication from the court, had not received any.
Although he did indicate during the hearing eventually that he received it. He just didn't read and signed it. He just didn't read it.
Was that the authorization to permit the records to be sent to his sister?
No, I think that was and I may be wrong, but I think he indicated that he received something from the court saying it had been dismissed. He just didn't read it. But I don't know, that may be an error.
Yeah, Judge, I'm not clear on that. The record speaks for itself, and I'm going to defer to your knowledge and your wisdom on that, but I am not clear on that.
Okay, all right.
I'm simply referring to the affidavit that he filed originally in the case. Yes, ma'am.
Okay.
So I guess the question at this point is whether or not I can, in a position to start talking about the second due process argument, the ineffective assistance of trial counsel in not suppressing or objecting to the blood draw in either a motion to suppress or at the trial of the case.
Right. Yeah. Yes, you can go ahead and talk about that. My understanding is the issue is the DNA evidence was key to one of the charges in this case, and the blood test was not requested in the search warrant, but was provided in response to the search warrant. And the attorney made no motion to suppress that evidence. And so that is the ineffectiveness that you claim requires reversal here.
Yes, Your Honor, that's perfectly correct. Yeah. So, yeah, and then obviously the basis for that would be the unreasonable search and seizure argument pursuant to the Fourth Amendment. My client employed the services of an experienced trial lawyer at the evidentiary hearing in this matter. That expert testified that obviously the blood draw was not authorized by the search warrant. The proper procedure would have been for trial counsel to have filed a motion to suppress or object to the introduction of the DNA evidence derived from the blood draw. There was no eyewitness testimony evidence at trial. The victim could not ID the assailant. The only link between my client and the victim was the DNA evidence. The expert that was hired by my client opined that without the DNA evidence obtained from the blood draw, the case would have been dismissed with the directed verdict, because without this evidence, there was nothing for the jury to consider. In other words, the case rested almost entirely upon the DNA tie-in between the perpetrator and the victim. Even the trial counsel for my client testified at the evidentiary hearing that his strategy was primarily to explain to the jury that the DNA samples could be contaminated. He was asked why he didn't move to suppress the blood draw. His response was the state could have gotten more blood samples, presumably from the issuance of a new search warrant. And trial counsel further conceded that the blood draw was used to formulate the DNA sample that was used against my client to convict him at trial. The district court in its decision cited a couple of different cases in support of its position on this issue. One was the Glenn case. One was the Schoonover case. In my brief, I pointed out that these cases could easily be distinguishable from the situation with regard to my client, the blood draw. Obviously, the statutory scheme for obtaining, executing, and returning a search warrant is set out by statute in KSA 2205, where the search warrant must specifically describe a person, place, means of conveyance, and the thing to be searched and seized. Obviously, as you pointed out, the DNA evidence was obtained from the blood sample. The counter to this claim by my client is that the district court also adopted the state's argument that the other specifically listed items in the search warrant could have produced the DNA profile, which could have been used to prosecute my client. But of course, we take exception, or my client takes exception to this argument, because if you permit this kind of what the difference argument is, then that renders Fourth Amendment jurisprudence protections moot. The use of the DNA evidence at trial from the blood draw obviously was extremely prejudicial to my client because it provided the scientific link between my client and the case victim. So with regard to the Fourth Amendment claim, the issue basically boils down as to whether or not the court wants to accept the state's argument that even if trial counsel had filed a motion to suppress and won, the state could have simply corrected the deficiencies with a new warrant, obtaining a new blood sample, or tested any of the other biomaterials that were seized. My client objects to this interpretation and this law argument. And so to sum up, the failure of trial counsel to suppress the search warrant prior to trial or to object to the introduction of the DNA evidence at trial based upon the blood draw would constitute a Sixth Amendment ineffective assistance of counsel claim. Your Honor, I think I've left.
Judge, you're muted.
Your microphone is off, Chief.
Sorry. You hit your time perfectly, Mr. Alexander. Any other questions from the panel before we go to the appellee? Okay, you may proceed.
Thank you.
Thank you, Your Honors. I will address the issues in the same order the appellant did. So beginning with the untimeliness. First of all, I would like to reiterate that the appellant focuses on 6260, but there's a specific provision in 6259F which applies specifically to motions to reconsider. And then 6206B specifically prohibits the court from extending the time limit under that subsection. So yes, there is 6260, which is the general rule, but under the present procedural posture, there's a more specific rule that says the court cannot extend the time limit. Beyond that, even if we apply 6260, as Your Honors noted, there's no reasonable justification for the delay. The defendant received, according to his testimony, it was a letter from his attorney in 2007, which told him that the case had been dismissed, but he did not read that letter. So any delay beyond that is due only to his own negligence. Had he read the letter, he would have known that it had been dismissed, and he would have known to either take appropriate action by filing a motion to reconsider or by appealing. But either way, he should have known at that time, and it's no one else's fault but his own that he didn't know for not taking the simple action of reading the letter he got from his attorney. So to say that he was unaware of the status of the case is based solely on his own failure to make himself aware. So I just can't see how anything beyond that is a reasonable delay. There's nothing causing the delay except for his own failure. And then regarding the blood draw issue, I keep saying defendant, the appellant keeps trying to go back to the underlying Fourth Amendment issue, which we dispute. But we're not at the trial stage here. So the issue is not whether the Fourth Amendment was violated. The issue was counsel ineffective? And if so, did that ineffectiveness affect the outcome? Counsel testified that he was aware of the problem with the blood warrant, but rather than antagonizing the judge by filing a motion to suppress, and then when the state could simply get a new warrant and fix the issue prior to trial, and he wouldn't have accomplished anything substantive, he would simply proceed on the defending on the unreliability of the blood evidence, which is where he would have ended up anyway had he filed his motion to suppress ahead of time. So that was a strategy by trial counsel upon considering all the issues, and any reasonable strategy by trial counsel cannot be overturned for ineffective assistance if it's on full consideration of the issues. Also, the argument that the appellant characterizes as what's the difference is at this stage exactly the point. It's his duty to establish that trial counsel's purported ineffectiveness affected the outcome of the trial, not that there was a violation in the abstract, but that violation actually affected the outcome of the trial. And as
Counsel, I've got a question for you, if I could. Do
Yes.
you agree with opposing counsel that the only evidence tying this man into the crime was the DNA evidence? In other words, had there been no proof from the DNA evidence, he would not have been convicted?
I don't recall the record in sufficient detail to say that was the only evidence, but I do agree that was by far the state's strongest evidence.
So if the DNA evidence had been excluded, he would have been exonerated. Is that what you're admitting?
There's a real possibility he would not have been convicted had the DNA evidence not come to this.
It seems to me then, if counsel didn't take steps to get rid of that evidence, that's seems to be ineffective.
But had he filed a motion to suppress, as the appellant says that he should have, as he testified, the state would have simply gotten another warrant or tested the other evidence that was legitimately seized. So it would not ultimately have excluded the DNA evidence. It would have simply have excluded the test results of this blood. But DNA evidence still would have come in that still would have tied the appellant to the charge. So it didn't actually, had he done the thing, it would not have affected the outcome. Some DNA evidence would still have come in. It just would not have been these specific test results of this blood.
You are arguing probabilities to us then.
Well, at this stage, it is his duty to show that the outcome would have been different had trial counsel acted differently. So yes, we have to argue about what would have happened had trial counsel done something else.
Thank you.
So I believe, yeah, we're talking about prejudice. So I believe I've addressed counsel's arguments. But does the court have any other questions for me?
No, thank you very much. You're not required to take up your time. Okay, Mr. Alexander, you have a couple minutes in rebuttal.
Your Honors, I would just simply direct the court to the direct appeal case that Ferguson filed before the Court of Appeals. In Ferguson's direct appeal, the appellate court pointed out at trial the victim could not identify who the intruder was because he wore a mask. The evidence that was that the intruder bound and gagged the victim and raped her twice. But the evidentiary link between my client and the victim was the DNA. And if there was no DNA, there would have been no conviction. I think what's the difference argument is that the burden would be on the trial counsel at that point in time to have done something to have suppressed the DNA evidence. I don't believe it is a credible argument for trial counsel to take the position, well, if I had filed the motion to suppress the DNA or objected to the introduction of the DNA evidence at trial, that I would have risked antagonizing the judge. That certainly is not a credible argument for a defense counsel in a serious criminal case. The point is that if defense counsel had done his job at the trial or before the trial, the DNA wouldn't have been admitted. My client wouldn't have been convicted. If the motion to suppress had been granted, then yes, it's supposition whether or not the state could have obtained the DNA evidence from the other items that were the subject of the search warrant, or perhaps there would have been a new search warrant issued. But that is speculation and water under the bridge. The point is, no DNA evidence at trial derived from the blood, no conviction.
Thank you. Any other questions from the panel? All right. Thank you very much, counsel. We will take this matter under advisement and issue a decision as soon as possible. Thank you for
Very
your
well. Thank
arguments
you.
today.
All right, take care.